Welcome everyone. Today we will talk about the new EU Copyright Directive. We're very excited that we have Paul Keller with us. Paul is an activist and consultant advocating for more flexible copyright policies. He is also an expert observer on the Europeana Foundation Board. He was instrumental in writing Europeana licensing framework, publishing framework, and Europeana public domain charter. You will also hear from my colleague Ariadna, policy advisor, and I will keep an eye on chat and Q&A. This is the last webinar in our series of webinar about copyright when publishing data and content with Europeana. You can find recordings of the previous webinars on Europeana Pro website, and we will link to the chat the recording of the last webinar, which was about open and reusable digital cultural heritage, where we heard about a case study from the National Museum in Sweden, and we also talked about benefits and challenges of open access and Open GLAM methodology. Ariadna and I are currently working on the short survey that we will circulate next week. So you will receive a few questions on the emails that you used to register for the webinars. And we would really appreciate it if you could spare a few minutes and answer those questions, because it will help us inform our strategy and future events about copyright and good copyright practice. And just a few housekeeping rules. You probably noticed that you're muted. If you wish to introduce yourself or give us your feedback, please use the chat and Q&A for all the questions. We will dedicate 15 minutes at the end of this webinar to answer your questions. And you will also receive a recording and slides of this webinar later on. We will share them with you via Eventbrite. And now I'm going to give floor to Ariadna and Paul.
Great, thank you, Marcia. So we've prepared a couple of questions for Paul, who will be taking us through the directive from the very basics to the specifics. And when it comes to specifics, we'd like to particularly focus, as you saw in the title, on Article 14 on the public domain and on the provisions, Articles 8 to 11 on out-of-commerce works, because they're likely to have we're hoping they will have a big impact in the cultural heritage sector. So we would like all of you to be aware of what they're about. And so starting from the beginning, Paul, here's the first question for you. Can you tell us what this copyright directive is about in general?
So hello, everybody, and thanks for organizing this, Ariadna and Masha. And I recognize like the bio that you read is not entirely correct anymore. I believe I'm now a member of Europeana's Advisory Council, and we don't have a foundation board anymore. There's lots of governance changes going on, but yes, for the rest, that was correct. So this is a good question, like about what is this copyright directive about? If you are not a person working in the cultural heritage sector and having an interest in copyright questions, the likelihood that you heard about the copyright directive is probably because somebody told you about upload filters or the end of the internet or a link tax or things like that. And these are some parts of the copyright directive which have gotten a lot of attention and have also very much shaped the political discussions around the copyright directive. But the copyright directive is much more, right? Like it's fully called the Copyright in the Digital Single Market Directive, and it is the first attempt of the European Union to change some of the basic rules of copyright since the 2001 InfoSoc directive. So if you want, it's really a attempt of the EU legislator to adopt certain rules in the copyright space to challenges that have emerged as a result of the increasing digital transformation over the last 20 years, or at least over the 15 years since the InfoSoc directive was adopted, and then these discussions started. And I think for our purposes, it's really the copyright directive really is about to answer to some of the challenges that have arisen in the cultural heritage sector. And what it does there is it clarifies some rules. For example, Article 14 is more of a clarification, but it also fundamentally tries to change the balance between the rights of users and the rights of rights holders in certain sectors. And that's in Europe, that's done via exceptions and limitations. So there is new or reshaped exceptions of limitations for areas such as online education, text and data mining, preservation of works in the collection of cultural heritage institutions. And then there is a number of provisions which are pretty wild mix between an exception and licensing arrangements that deal with the making available of out-of-commerce works. So it's really like a modernization of some of the copyright rules, and there's a specific focus on, if you want, public interest users in this thing. So cultural heritage institutions, academic researchers, educators.
Okay, great. So with that in mind, let's move on to the second question, a bit more about timelines, sort of. So when was this directive adopted, and when will the provisions be enforced in member states?
That's a good question. So the directive was adopted at the very end of the last European Parliament's term, right? Like in April 2019. After that, we had the elections to the European Parliament and the new Commission. In between that, the directive was signed into law or published in the official journal of the European Union on the 7th of June 2019, and it has what's called a 2-year implementation deadline. So the member states, a directive does not apply directly to it does not apply directly, but it applies through national implementation. So it directs member states to change their laws so that they implement the provisions in the directive, and member states have 2 years for that. For people who are keeping count, that's basically Monday in 6 months when those 2 years are over. Now, there's now 2 answers to when the provisions will be applicable. Like if member states do not implement the directive, the provisions of the directive apply directly because the member states have failed to do so. In fact, in most cases, really, the reality is that kind of like changes come into place once the member states have put in place their national implementations. So far, no member state has implemented the entire directive. There's 2 little parts which have been implemented: an education exception in Hungary and the new neighboring right for press publishers in France. And for the rest, nothing has been implemented. The Netherlands is the country which is furthest along the implementation curve. Like it has cleared the lower house of parliament and is currently in front of the Senate, the first chamber of parliament here. So there's probably my guess would be a small number of countries, in any case, including the Netherlands, who will have an implementation ready before the implementation date. Probably a number of other countries will follow over the summer and maybe the latter half of 2020. But provisions, like in theory, like it takes effect directly on the 7th of June 2021.
Okay, so Paul, that sort of means that let's say the benefits of this directive, like the benefits of the out-of-commerce works provisions, etc., we won't see any practical results until at least that point in time.
Yes, that's very likely. Like some of the things, like basically you can know some of the, what you have to deal with, right? Like and some of things like digitization projects obviously are always like very long running projects that take a lot of time, that take a lot of effort. So obviously I know here in the Netherlands, but probably also in other member states, maybe there's organizations already anticipating on it. But for example, this one provision, which we're going to talk about in a bit on the out of commerce works, also has a very important step that you need to register something in a portal that is operated by the EU Intellectual Property Office. And the plan there, for example, is that this portal becomes operational. So the website goes live on the 7th of June, 2021. So you can't do the required steps before that date. So it's really like in 6 months from now, things change. And in some countries, it may take a little bit longer till the procedures and rules are really set in stone.
Okay, noted. Maybe let's start diving a little bit further into the details. What would you say are the most interesting provisions for cultural heritage institutions in the directive?
So we have the two that we're gonna talk specifically about it, the out of commerce works and the Article 14. So let's leave them aside and say like there's one other one which is exclusively aimed at cultural heritage institutions, which is Article 6, the new mandatory exception for preservation copies, right? Like it allows cultural heritage institutions for the purpose of preservation to make reproductions of works that they have in their collection. This is something that was possible in some member states, but not in all of them. So there's now clarity that something which, if you look at it like that, an institution should be able to preserve the works that it has in its collection. A public institution seems like a little bit like a no-brainer, I would say, something that is clarified and is made clear that cultural heritage institutions all across the European Union have the same rights here. So I would almost call that again like a clarification, adoption to common sense here almost. It probably won't change a lot in practical terms, but it will take away some of the legal uncertainties surrounding these practices and maybe make people worry a little bit less. Like it also shows like it clearly emphasizes that this is important work, which is that preservation is important work that's being done by institutions all across Europe. And then another thing which is probably also interesting for cultural heritage institutions, and it's probably going to become more interesting, they are also a beneficiary of both of the exceptions relating to text and data mining. So text and data mining is, I guess, another term for computational analysis of large data sets and extracting information from large data sets. And there has always been some uncertainty if that was actually allowed under copyright rules or not. And now the US legislator has made it very clear that it is allowed for scientific research or academic research organizations and cultural heritage institutions, as long as it's done for purposes of academic research. And it is allowed for everybody else for all purposes, unless the rights holders reserve that right. So this means that that can be interesting. Text and data mining can be interesting for cultural heritage institutions themselves, trying to better understand their collections. Maybe like it's often a step in processes that are generally known under this label of artificial intelligence. So it can be enabling processes there, but it is also probably something that that can be interesting when cultural heritage institutions serve researchers or other clients who come to them and say, like, we would like to do large-scale computational research on that collection of yours, right? So there's clear rules for that. And it clearly shows that this is in any case allowed, with a couple of considerations around it around data security, etc., if it's done for scientific research purposes. And the remaining, like there's in total, like I think there's in total something like 13 like effective provisions in the directive. Most of the other ones do not directly relate to cultural heritage institutions. Often cultural heritage institutions have maybe relationships with educational institutions, so it makes online it clarifies the legal status of online education in a lot of cases, which may also be relevant in some contexts where cultural heritage institutions operate. And then the other provisions are very much interventions into what I would call commercial value chains at different places. So for example, where it affects search engines and press publishers, or the relationship between user-generated content platforms and like rights holders, or also like there's a number of provisions between, for example, individual creators and intermediaries like publishers or music publishers in that sector. So the contractual relationships between people in the value chain. These are generally not things that that cultural heritage institutions interact with a lot. There's one more optional provision in the directive, which is Article 12, which allows the introduction of extended collective licensing schemes for areas other than out-of-commerce works. So this may also be something that becomes relevant to cultural heritage institution, but it's a bit difficult to say in which sense, because it is optional, and it is a sort of umbrella provision that allows member states to do certain things via extended collective licensing without describing what kind of things. So like there may be some extra wiggle room in copyright legislation in member states who introduce these provisions, but it's a little bit early to say in how far that is really becoming the norm and in how far that is relevant for cultural heritage institutions.
Okay, great. So there's the provisions that we'll talk about in a second, and then you talked about text and data mining, preservation, provisions more related to platform liability, extended collective licensing, and I can't remember now if you talked about the educational exception, the educational provision as well, and to what extent you think that might apply to cultural heritage institutions or not.
It does apply to culture. No, wait, like no, I should check the text because there isn't certain. So it's definitely interesting, right? Like it's I talked about it a little bit. I think it is an education, or it's an expansion of the educational exception mainly for cross-border online activities. So it makes it clear that certain online that basically carrying out educational activities in online environments is something that is falls under an exception, or it's a little bit like a tricky provision, or at least it needs to be licensed in certain ways that makes it very easy to access for the educational institutions that want to carry out such activities. I think it's mainly the main beneficiaries really will be classical educational institutions, and as we've seen over this year, like online education is something that has become much more important. It's interesting to see that one member state, Hungary, has actually jumped on this opportunity and basically taken only this part of the copyright directive very much at the beginning of the pandemic, and has introduced in its copyright law these expanded provisions that basically extend this exception to apply to online users, very specifically in order to say, like, we need to create more legal certainty to educators under these circumstances. So I think it's important. And I mean, there's educational departments in cultural heritage institutions, there is collaborations, but I think the main benefit there really goes to like the classical educational institutions.
Right, okay, thanks. So maybe we can start diving into the details of one of the provisions that I think will have the biggest impact in the cultural heritage sector, which is the out-of-commerce works provisions. So can you maybe tell us a little bit more about that? And we're doing great on time, so you can take as long as you want.
Okay. Don't tell me I can take as long as I want. That's dangerous. So this is one that that is probably the most important one for cultural heritage institutions. It is something that also we are really happy that it ended up in this directive. It wasn't necessarily clear that it would be at all times. It is something that Europeana and lots of individual organizations and the organizations representing museums and libraries and archives in Europe have also lobbied for quite intensively. So it's something that you can say we fought for. Interestingly, and maybe as a result of this very much attention on the Article 17 and Article 15, the more controversial parts, it wasn't necessarily like a fight in the sense that there was a big conflict between different parties, but in the shadow of these big controversies, like there were actually pretty productive conversations between culture heritage institutions and publishers and collective management organizations and other types of rights holders. So this is something that evolved quite a bit from the beginning, what was proposed by the directive to the end, but very much based on input from stakeholders and conversations among stakeholders. And what has come out of it is, maybe first what it tries to address, right? Like it tries to address the fact that clearing the rights for copyrighted works that are still in copyright, but that they are not or have never been commercially exploited can be very difficult and time consuming. Think about old books, old newspapers, old magazines, but also photo collections in archives, old archival film footage, old kind of like film commercials, like generally unpublished works, collections of posters, collections of manifestos, all kinds of things that has been kept by cultural heritage institution, but that is not like where it is not easy to simply look up the rights holder and get in touch with the rights holder or representatives of the rights holders and say, hey, can we have this in our collection? Can we use this? And this tries to answer to this, not so much in an individual case, but really like for larger collections. So think a large newspaper digitization project with maybe like 1 million pages, or think about these proverbial boxes of old photographs that are somewhere in the basements or in the attics of municipal archives. Cases like this, or collections of like hundreds of political posters from the social movements in the 1970s, right? Like they usually also don't say, hey, this is copyright by this and this person and they can be reached at this and this address. So there's a clear problem. And like we've in the process, we've also shown this at Europeana, that there really is what we called at that time a 20th century black hole. So there is, because of copyright problems, a lack of availability of material from the 20th century, and specifically the second part of the 20th century, right? Like it is very, very difficult to digitize large amounts of materials from that period because it's still in copyright, and a lot of that is not commercially exploited anymore. So the provision is supposed to address this class of things. So it's something that is in between the pure orphan works, where it's kind of like next to impossible to identify the rights holders, or at least find them and get permission, but where there is still like substantial problems, and where it's often economically like just not feasible to carry out these one-by-one searches, because like that is in no balance with the cultural value of these works and making them available. And so the provision intends to make this to facilitate these processes, and it emerged something which is quite complex. It's actually 4 different articles in the directive that deal with this thing, that are all parts of this problem. So it's articles 8, 9, 10, and 11. And these articles basically describe a 2-tiered or like a 2-layered system, which says we will try to solve this problem by collective licensing wherever it's possible. And when it's not possible to solve this by collective licensing, then there is what became to be known as a fallback exception. So if it's impossible to license, then there is an exception. And so the approach, and like I've tried to summarize that in the flowchart that you will see on the page, is for a cultural heritage institution that wants to clear the rights in a collection of works for which like the copyright status is very unclear. Like the first thing is to determine, is this really a collection of works that are out of commerce? So is this, like, if it is a collection of books, like it is something that is relatively easy to check, because like there's these books and print lists, for example. In other cases, that's probably like a little bit of a judgment, and the definition of the directive there is not available through the customary channels of commerce, whatever that can differ quite a lot for the types of works, because obviously the customary channel of commerce is something completely different for a poster, a book, or a feature film, right? But if you come to the conclusion that this is a collection of works that are not available through customary channels of commerce, then the next question is to figure out if there is a representative collective management organization that can issue license for these type of works. For example, in the literary sector, like this will very often be the case, or in the musical sector, like there's a collective management organization in almost all the member states. In certain other sectors, that is not so clear. Some sectors like visual arts, like the picture is a little bit more spotty. A lot of member states have visual arts CMOs, but some of them don't. And if you come into a sector like audiovisual works, there's generally not a lot of collective management that covers these types of works and that can actually issue licenses for the use of them. So you need to look at the collection and figure out, is there a representative collective management organization? If the answer is yes to that, then this first layer kicks in that I described, where it is about trying to get a license from that CMO, and that can be an extended license that is for their members, and then it's extended to apply to all other rights holders that are also represented in that collection. That's why it's called extended collective licensing. So it is a process of then approaching that collective management organization, trying to agree on the terms of a license, and then making that collection available under the terms of this license. There is an extra step. You need to announce this and publish the intention to digitize and make available these works 6 months ahead through a centralized database maintained by the EU Intellectual Property Office. We'll come to that in a bit. Wait for 6 months if somebody says, like, I really don't want this out there. So it's called what's called an opt-out. And if that 6 months has passed, like, these works can be published online. So that's the one route. The other route, if there is no collective management organization, suppose like you're dealing with a large collection of amateur films, like that are part of the collection of a municipal or regional archive or something. Like, we know that there's probably in very, very few cases, there's actually collective management organizations who are representative for amateur films that have been produced somewhere in the 1970s or something. In that case, you establish that there is no representative collective management organization. Then the fallback exception kicks in, and that basically says, under these conditions and under a number of other conditions, like give credit to the author, only deal with works that you have in your collection, only use them for non-commercial purposes, you can make these available on your own website by law, right? Like, so in this case, like, you do not need to negotiate with someone. You need to be sure that there is no one to negotiate with. And then the law, those implementation, once these laws are implemented, gives you the right as a cultural heritage institution to publish these works. Again, under the conditions that you first need to announce this, wait for 6 months, and then it can go online. There is a lot more complexity to this, like how you deal with like third country works, how certain other specifics, but like this is the general overview of this. And the important thing to really keep here is, like, this is really designed to like, the intent of the legislator here is really to get this material out there, to allow institutions to make this publish. And the general deal is license where you can, like, also do this under a license whenever possible. And when that is not possible, there is the fallback exception for you that gives you the right to do this, right? So there is not a, like, these two mechanisms are not pick and choose whatever serves you best, but they are really like in a hierarchical collection. So you first need to try the licensing and then fall back on the exception.
Okay, Paul, there's a couple of concepts in there that maybe I just wanted to quickly ask you. Who decides, or when is it clear that a collective management organization is representative or not, or what should a cultural heritage institution wait for before they know they can apply the exception?
So a couple, these are like, this is one of the concepts that we have, like we have text on the EU level in the directive, but like I think it is very important to wait for the national implementations, because the situation, how collective management organizations are organized, in how prevalent they are, or it differs a lot between member states. And so the specific rules for when an organization can be considered to be representative or not are probably only going to really appear in the implementation process on the national level. And we haven't really seen a lot of things there. We know, like, often this is also something that even the implementation laws seem to have the tendency to delegate that then to later, like, secondary acts of government, where there might be like some administrative decree that describes these conditions, or that governments will first like consult stakeholders in order to figure this out. But this will be determined on the national level, and it's a little bit too early to really give an answer to that question at the moment. And the same is to some degree true also for the exact definition of when a work is out of commerce or not. So the directive leaves some leeway to member states there, and also has some encouragement to maybe make this a little bit more practical. So one of the things that is more or less suggested in the directive, but like not a hard rule, is that member state might consider working with cutoff dates. So for example, say everything that is older than 60 years can be considered to be out of commerce without search, but like everything that is newer, things like that, right? Like, and the directive also said that this should really on a category by category basis, like be something that is determined in consultation with stakeholders. And we haven't seen such stakeholder consultations yet.
Okay, and so how about like the very last box, which has a cross? And I think you've reiterated many times how important it'll be for cultural heritage institutions to sort of try to learn how to negotiate licenses, because the success of this provision and its applicability depends on it to some extent. Maybe you have some thoughts on that.
Well, it is so this last box, like I think you're referring to the one with the cross, right? Like left down, right? Yeah. So there is no absolute right in here to make something available. So if there is if there is a representative collective management organization, and you cannot come to, you cannot, like the institution that wants to digitize the collection and make it available, and the collective management organization cannot agree on a license, that's kind of like an end of the story thing. So like you can't, and that doesn't help you in the sense that this scenario, like you could imagine a scenario where collective management organizations, okay, first we try to negotiate something, but like we'll just simply not agree to whatever the outcome is, and then we can make out of then we can make of the exception. That's not the case, right? The case is really like, if there is someone to negotiate with, this needs to be resolved through negotiation. Only if there is no partner for negotiation can you rely on the exception. And so this may be like this may be a bit of a challenge in adoption for cultural heritage institutions, right? Like many institutions are simply not used to the kind of like commercial type of negotiations. You have to pay X amount in order to be allowed to do this, and may also see that as somewhat alien to their thing. But like on the other hand, these collective management organizations obviously like are there in order to make sure that the rights holders, where they are still around and still want to receive income from the use of their works, get this. And there is a mutual, like there is a mutual interest between the culture heritage institutions and the collective management organizations in coming to some kind of like agreement, right? Like the institutions will have an interest in making their collections available, but not at all costs. And for the collective management organizations, there will be an interest to get some money out of these transactions in order to be able to pay that out to creators and other rights holders. And so there's also no, like, if they refuse a license, like also they don't have any, like they don't achieve anything. So there's, I think the important thing is like, and that's really like the design principle of this provision that says like, we trust these two types of entities to where they can talk to each other to solve these problems for the mutual benefit, right? Like, and that is a mindset that I think is good to realize, and this before going in there. This is not like a carte blanche to say like you can now make everything available, but this provides a relatively well-structured path to making much more of the collections in Europe's cultural heritage institutions available.
Okay, great. So we're going to move on to sort of another provision and keep posting your questions in the chat and Q&A so that we can take them at the end. Oh, actually, yeah. So here's a question about, you've talked about the portal in which CHIs will have to declare the works 6 months before they can benefit from the provisions. So how will this EU IPO portal actually work?
Can you go to the next slide? Yeah. So this is a screenshot that like of like a mock-up, which I think is interesting. It's clearly inspired by Europeana to some degree, right? Like, but this is not the image I think is even taken from Europeana and properly credited to Europeana, and it's kind of like the same approach. Like, it's a search engine, right? Like if you go in there now. This is not a search engine. These works don't reside in there. This is, first of all, information about works, right? And so how this works is basically a 2 or 3 step process, depends a little bit on what you look at. The first is this requirement, like if you come either to an agreement to license a collection with a collective management organization, or if you make a collection available under the exception. The first step is that the cultural heritage institutions will need to provide information to this portal, descriptive information about these works. So like it could be like the titles of books or ISBN numbers of books, or and the names of authors, or in the case of artworks, the names of authors and maybe a description. Like, it depends very much on the title. Like, you try to describe these works either on the collection level, but preferably on the individual works level. This will be something that can be done as far as we understand. I mean, this portal is still being developed, either like individual via a web interface, but they are also building ways to like bulk upload information, so process batch information. So you can provide like maybe an export from a collections management system, and that's then ingested in there. The purpose then of this portal is to display this information, to allow rights holders to or other people interested to look up if there's something in there that they might not want to have available online. So it then allows an author to check if his or her works are available in this thing. And if they find something and identify themselves as a rights holder, they can also opt out. In which case, like, the information is communicated back to the cultural heritage institution and told, by the way, we received word from this author or this publisher or this organization saying they do not agree with that, and then you have to remove this. So that's the main purpose of this 6 months, like however you want to call it, waiting period or cooling off period, to allow rights holders to exercise their right to opt out. So the EU IPO, which is responsible for building this portal, has been engaging in discussions with representatives from Europeana, from other cultural heritage institutions, also from rights holders and CMOs. And like, I think what we all said, like, is we want this to be as easy as possible. This should be like preferably as much automatic connections. There should also be things like automatic notifications. So if something is uploaded that matches, like that the parties get informed automatically back. Like how this is going to work in practical details, like we will still have to see. The plan of the EU IPO is really to launch this on the 7th of June 2021. So on the day the directive becomes effective. I think they are currently looking for or working with some partners trying to do pilot testing with like real data sets. And their current planning seems to be that there also will be some limited possibility for public testing of the portal around April, I think is what they have communicated. So around that time, people interested in this process will probably have some possibility of familiarizing themselves with like the functionality of the portal.
Okay. So now leaving the subject.
And maybe one more important thing how this works is like there's a similar thing like also by the EU IPO for the Orphan Works Directive, where like the interaction with the portal is something that goes via national competent authorities. So it's an indirect relationship between most of the cultural heritage institutions who use that and the portal that the EU IPO maintains. Here, the idea is that this will be a direct relationship. So you will have like the institutions will directly be able to add data to the portal or modify data to the public and be informed about changes there.
Okay, cool. So yeah, let's move on to the provision about the public domain. So I think that's one that you particularly like. Can you tell us a bit more about it?
Yeah, can you slide? So it's compared to the provisions on out of commerce, it's not short and sweet. This is the entirety of it. So like in more detail, like you can read this. This is basically all the detail there is. But I can give you a little bit of background, right? Like Europeana, so for example, in 2009, we started working on our public domain charter. And one of the things that this public domain charter addresses is that we think it's undesirable if museums or libraries or archives or basically anyone who digitizes a work that is in the public domain then claims copyright in the digital copy of that. And Europe, being a very diverse and having diverse like legal traditions, had very diverging legal arrangements. In some member states, this is plainly not possible. Like you don't get any copyright if you make a perfect digital copy of something. And other member states have legislation that emerged from discussions around the protection of photography often that resulted in the fact that there's actually specifically new rights for like making mere copies of a work, right? Like so in some member states right now, until the directive is implemented, Spain is an example, Germany is another example. It is the case that if you make a perfect reproduction of a work that is in the public domain, you as the photographer or maybe then as the employer of the photographer have the right to claim exclusive rights over this reproduction. That's why you can, for example, find like paintings of Rembrandt on the internet with names of museums under it, with a copyright sign on it, and which is counterintuitive, right? Like the author of these works has been Rembrandt from Rhine. He's dead like for more than like 70 years. Like this should be in the public domain, but because of this legal arrangement, that's perfectly in line with the law, right? And Article 17 tries to change this, and very specifically for the situation where it is about digital reproductions or reproductions of works in the public domain, works of visual art. And so it instructs member states to ensure that the situation is the same in all member states, namely that if someone makes a reproduction of a work that is in the public domain, and that reproduction is a mere technical copy of that thing and not like an author's intellectual creation, so not like some artistic reproduction that somehow changes, adds something to it, then there can be no copyright or other related rights to it. So it ensures that reproductions of public domain works stay in the public domain, right? And so this is a provision that in some member states, it will be completely ignored. For example, the Netherlands, which has already basically adopted its thing doesn't even deal with this provision, because like the situation has been like this in the Netherlands, whereas in, for example, Germany, which has various versions of the implementation law and consultation, they contain an article which basically describes this in German and says like as a change to our general principle that protects non-original photography, non-original reproductions of works that are in the public domain are not protected. And we expect about half, like roughly half of the member states probably need to change their law as a result of this. So need to remove this form of protection from their copyright laws, and roughly the other half of them probably don't need to change anything because the situation is already as is.
Okay. I'd be tempted to ask a couple of things about this one, but I think we've got some interesting questions in the chat. And one last question before we dive into those. So maybe I'll move forward. I think you already hinted what happens next with the previous things you said, but that's the last question for you before we go to the questions in the chat. What do people need to watch out for at the moment?
Well, what happens now is that probably most legislators are in some level of activity in transposing the directive, right? And it seems to be progressing relatively slowly. So we don't have anybody who has adopted this. We only have 6 months to go. Part of that is probably due to the pandemic, which like halted certain processes earlier this year. Part of it is also because like there's still some kind of like unresolved questions around Article 17 specifically of the directive, which was the most controversial one of the directive. And we get the feeling that some member states are, for example, waiting for the Commission to publish some guidelines on it. There's also a court in front of the European Court of Justice that probably some member states would really like to know what the outcome of that is before they move forward with implementing that, although that's not realistic. So, but rest assured that in most member states, people will be working on this implementation. And that is the work. There's also not in the provisions that affect cultural heritage institutions, there's not so much choices to be made. Like it's really like a technical work of transposing these things. But what should happen also is like cultural heritage institutions figuring out how they want to make use specifically of the provision on out of commerce works, right? Like, and so there's two things which would be like which would be good if they were happening from my perspective. One is like engaging with the relevant ministries on trying to see like how cultural heritage institutions' ideas can be heard when it comes to kind of like these definitions. So, for example, the definition of what exactly is an out-of-commerce work, or what exactly does it mean for a collective management organization to be representative. That's one, so reaching out. But on the other hand, like maybe also establishing connections with collective management organizations that are relevant in this sector. Maybe talk to them, hey, in half a year, like there will be the possibilities for us to make these kind of deals. Have you already thought about that? Like we would, or maybe already present, like we have ideas, we have these collections that we would like to start with, and start building a relationship where you can have a discussion about like how to move this forward. Because like I think really from the perspective of lawmakers who have listened to the cultural heritage sector basically saying like we need better rules in order to make more materials online, the ball's not right now, but like in 6 months from now, the ball is really in the court of the cultural heritage institutions and the collective management organizations to show that this can work, right? Like that this effort of getting this directive on paper is worth it, and that will be shown by institutions like going and using these provisions and making works available under these provisions.
Great, thanks. So I'll hand it over to Masha now because she's been monitoring the questions in the chat and in the Q&A, and so let's see what the public is thinking.
Yeah, thanks, Paul and Ariadna. So we have 3 questions. One of them is about Article 14, which you talked about just now. So let's start with that one. And the question is, if the Open Data and PSI Directive continues to give institutions the right to charge for supplying digital content, isn't there a risk that Article 14's impact on driving more Open GLAM practice will be limited?
So I don't think so, right? Like there is the whole provisions around open data and the PSI directive, like I think are very much in flux still, not the directives themselves, but there's clearly like a very high level discussion about making data available for the common good going on at the level of the European Union. So there is a general trend towards more openness in data, specifically where it comes from public institutions, right? And the like, even if there is the ability to charge, like that probably was never really that is not necessarily something which only comes from copyright, right? Like this is more a change of minds that I think is a continuation of the open data approach, the PSI directive, and now Article 14 that tries to make it sure that where something is in the public domain, it really like it is in the public domain, so it can benefit the public. And so I would probably see this more as an element that will further accelerate this trend towards what's called open GLAM as well. Like it removes uncertainties there, right? And it is something that is, maybe it limits a little bit like the ability of people trying within culture heritage institutions trying to experiment with different business models here. But on the other hand, it's also like a substantive provision. Like it gives open data advocates within organizations, but also outside of organizations. Think organizations like Wikipedia, who has been sued in the past in Germany for basically publishing public domain works. It gives them like also something in the law to work with. So I'd be confident that this is more a step in the right direction than that to worry too much about the open data and PSI directive in this case.
Okay, thanks. And then we had one question that was asked at the very beginning when we talked about the timeline and implementation of the directive. Is there a risk that the contentious provisions will delay those relevant for CHIs, such as out-of-commerce works? What can we do to avoid this?
I think the second part of the question, like, I'm afraid not very much, right? Like you cannot avoid delays. Like there's a couple of things we need to face. The first thing is like almost no member states ever implement like anything on time, right? And this will probably be especially pronounced with the pandemic this year. Like we've just seen, for example, that the Audiovisual Media Services Directive, like that was supposed to be implemented 2 months ago, and like the Commission just sent out or started procedures against like I think 23 of the 27 member states who have not implemented. So, and this is pretty normal, right? Like, and then there's an angry letter from the Commission, and so like I think like I wouldn't even really consider stuff delayed if member states somehow implement this within the remainder of next year. But on a practical level, right? Like it's also the case that like if it's not implemented into national law, then these directives apply directly. So you can also put yourself on the provision and go ahead and make use of these provisions. And like a practical thing, for example, is that would mean the EU IPO portal, at least the EU IPO tells us this, and like there's no reason not to believe them, will be operational on the 7th of June. So you could also start putting in like information about works that you intend to make available in 6 months, puts pressure on the legislator, right? Like I wouldn't, so I wouldn't worry about that too much. Although it's probably true that where member states decide on working on the resolution of these contentious issues, it is very likely that it will delay like all of the implementation of the copyright directive. So It's not, but we've also seen some member states, for example, France, to separate out parts of the directive and address them depending on complexity and urgency at different speeds. But right now, I mean, 6 months is not a lot of time left, and we're going, and basically, like, there's Christmas, the New Year in it, like, which is almost another lost month. So, like, we're coming awfully close also to the implementation deadline there.
Thanks. And now, last question about out of commerce works that was posted in the chat. And it's asking, what about transnational CHIs and their relations with foreign collective management organizations?
This is a good and very broad question, right? Like, so it depends, probably a good answer. There are very specific rules in there, kind of like that deal with, and there's multiple sides to this question, right? I think generally the directive assumes that a cultural heritage institution is located in an individual member state or is publishing from an individual member state. So, like, the transnational status is probably something that would be resolved down to like some proxy member state, right? Like, that's not the biggest problem in this, as long as this institution can make the claim that it's based in the European Union, because this applies to organizations who operate like cultural heritage institutions established in the European Union, right? And then relations with foreign CMOs, here it becomes very, very complex, I think, to some degree. Again, it assumes that there is a organization like a CMO in the European Union that is representative for those collections. And that could, in theory, be not, that does not have to be a CMO which is established in the same member state as the institution is. For example, if you are, for some reason, I don't know, like a French library specializing in Swedish books, right? Like, then it might be that the representative CMO is not the French literary as CMO, but like it might be like that it's actually better, like, give this organization, the CMO in Sweden, a phone call and say, like, hey, we're having this collection where we think it's out of commerce works, and can we work with you on getting a license, right? So there's some rules to it that I think are very much case by case determinations in the end, how this works. There's the other part to this is also that generally CMOs tend to have also agreements among each other that they can represent the repertoire of what they often call their sister organizations in other countries, and issue licenses for that. That's something that is fairly common in some sectors, not so common in other sectors. But we would also, because of this more like this renewed emphasis on this mechanism of extended collective licensing for out of commerce works, one could imagine that this also on the backside of the system. So among the CMOs, there's more coordination in order to facilitate, like, covering collections that are comprised of works from creators that come from many different member states.
Okay, and that was the last question. So I suggest we end it here. Thanks so much, Paul. That was very useful and informative for all of us. And thank you everyone for joining us. You will receive a recording probably next week.